In the General Guidelines of 1991 and the General Comment on number 5 of 2003, the Committee on the Rights of the Child identified 4 provisions of the Convention on the Rights of the Child as guiding principles to help governments, parliaments, the judiciary in the interpretation of the Convention as a whole and whereby to guide its implementation. These principles are the right to non-discrimination under Article 2, the right to see children's best interests assessed and taken into account as a primary consideration in all actions and decisions affecting them under Article 3, paragraph 1, the right to life, survival and development under Article 6, and finally the children's rights to express their views and be heard under Article 12. Given their central role in the implementation of the Convention, these principles are directly relevant when analyzing how children's rights can be affected by climate change and environmental damage, and what are the relevant obligations of states to respect, protect and fulfill these rights in relation to the threats posed by climate change and the threats posed to biodiversity, natural resources and ecosystems. Let's now focus on each of these 4 principles. Children's rights to protection against discrimination under Article 2 entails states' obligations to respect and ensure the rights set forth in the Convention to each child without any discrimination. This requires states to actively identify individual children or groups of children whose rights to be realized may demand special measures. This, for instance, entails that states must ensure that the policies adopted in response to climate change duly take into account the rights and the vulnerabilities of all children under their jurisdictions, including children of minority groups or children from indigenous, low-income or other marginal communities, which are often at the higher risk. Accordingly, as expressly highlighted by the Office of the High Commissioner of Human Rights in a study of 2017, states must focus adoption measures on protecting those children most vulnerable to the impacts of climate change. Focusing on Article 3, paragraph 1 of the CRC, the best interest of the child is a dynamic concept requiring an assessment appropriate to the specific context. As highlighted by the Committee on the Rights of the Child in General Comment number 14 of 2013, the best interest of the child in its functions as substantive right, as an interpretative legal principle, and as a rule of procedure can help to guarantee the full and effective enjoyment of all the rights enshrined in the Convention and the holistic development of the child. The CRC neither provides an exact definition nor indicates how to determine the best interest of the child, but it nonetheless requires that this must be the determining factor for specific actions under Article 9 and Article 21, and also that it must be a primary consideration for all the other actions affecting children, whether taken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies. In this regard, for the Committee on the Rights of the Child, the latter are required to apply the principle by systematically considering how children's rights and interests will be affected by their decisions and actions, including actions that directly or indirectly affect children. Importantly, among the elements to be taken into account when assessing and determining the best interest of the child, the CRC Committee has included the child's situations of vulnerability, highlighting that this principle demands authorities and decision makers to consider the diverse kinds and degrees of vulnerabilities of each child, and so requiring to carry out an individualized assessment of each child's history and recommended reasonable accommodations throughout the child development process. In this context, in general terms, it can be argued that the best interests of children are negatively affected when the consequences of climate change lead to an increased risk of natural disasters and of natural hazards impacting children's protections and disrupting education. In this vein, states should ensure that the best interests of children are primarily considered in the formulation of policies affecting climate that can generally deemed to fall within the expression action affecting children under Article 3, paragraph 1. As emphasized by the Office of the High Commissioner for Human Rights in the aforementioned study of 2017, the incorporation of the principle of the best interest of the child throughout disaster risk reductions, sustainable development, and climate change actions is key to protecting children's rights in a changing climate. Significantly, human rights commitment contained in the CRC and the Paris Agreement made clear that states have affirmative obligations to take actions to protect children's rights and best interests against actual and foreseeable effects of climate change, and failure to take adequate steps to protect children from suffering foreseeable climate-related human rights harms breaches these obligations. Looking at Article 6 of the Convention, this enshrines the children's inherent right to life and states parties' obligations to ensure to the maximum extent possible the survival and development of the child. For the CRC Committee, states are expected to interpret the term development as an holistic concept, embracing the child physical, mental, spiritual, psychological, moral, and social development, and implementing measures should be aimed at achieving the optimal development of the child. Therefore, safeguarding children's survival and development necessitates comprehensive measures and provisions, allowing them to grow up in a healthy and protected manner, free from fear and from want, and to develop their talent, their personalities, their abilities to their fullest potential consistent with their evolving capacities. In this regard, children's right to life, survival and development implies for states that when adopting and implementing climate policies and measures, such right must be primarily considered, and this inter alia entails states' duty to take measures to prevent the loss of children's life as a result of climate-related natural disasters. It must be highlighted also that the rights under Article 6 can be directly at risk from climate change-related disasters such as floods or extreme weather events, and from the loss of biodiversity, ecosystem degradation, or resource depletion. But also the rights under Article 6 may be indirectly at risk from increased probabilities of disease and hungers as a result of such disasters, and even from more structural changes in the living environment, which are produced and aggravated by global warming, such as drought or wildfires. As Article 6, paragraph 2 requires states to ensure to the maximum extent possible the survival and the development of the child, this implies that in their climate-related policies, states must take highly ambitious measures to protect children's lives from the risks posed by climate change. At the minimum, states should therefore comply with their internationally agreed upon targets in terms of greenhouse gas emissions reductions, and in particular their nationally determined contributions adopted in the context of the Paris Agreement. Furthermore, in line with Article 4, Paragraph 6 of the Paris Agreement, states should adopt more progressive emissions reductions targets in their next nationally determined contributions to be adopted every 5 years. Focusing on the last but not least general principle of the CRC, Article 12, Paragraph 1 of the Convention requires states to ensure to children who are capable of forming their own views the right to express these views freely in relation to the matters affecting them, and that these views be given due weight in accordance with their age and maturity. For the Committee on the Rights of the Child, these principles highlights the role of children as active participants in the promotion, protection, and monitoring on their own rights, and applies equally to all the measures adopted by states to implement the Convention. Certainly, climate change falls within the scope of the expression all matters affecting children under Article 12, Paragraph 1, because the children of today and the children of the next generations will bear the economic, social, environmental consequences of inadequate and ineffective climate change decision-making. Therefore, Article 12 should be interpreted to cover also children's rights to express their views on how themselves, their families, their communities, their governments, their parliaments, and even the international community as a whole should respond to climate change and environmental degradations and its consequences, as well as their views on existing actions and on existing environmental laws, policies and practices taken to address climate change and environmental harm that concern them. Moreover, under Article 12, Paragraph 2, children are to be provided the opportunity to be heard in any judicial or administrative proceedings affecting them, either directly or through a representative or in an appropriate body. And in this regard, states are required to take appropriate steps to empower children and ensure their access to any child-sensitive judicial or administrative processes, which also will contribute to safeguard their access to remedies. In this context, already in 2016, during its days of general discussion on children's rights and the environment, the CRC committee highlighted that states should empower children to participate in environmental policymaking, including through climate change education and consultative mechanisms, by developing in particular innovative mechanisms to allow children to be recognized as stakeholders with the right to be heard and taken seriously in decision-making related to the United Nations Framework Convention on Climate Change, the Convention on Biological Diversity, and the COPs, etc. And also to be involved in the design and delivery of projects related to climate change adaptation and mitigation, disaster risk reductions, or nature conservation. These positions have been then developed in more recent resolutions also of the Human Rights Council in 2019 and 2020. In this context, it must be also noticed that the right enshrined in Article 12 is crucial, and together with the right to information under Article 17, ensure that children can express themselves and be informed about climate change measures that directly concerns them. And in this regard, children's access to reliable information about the risk regarding the effects of climate change on their living environment, as well as about the policies and measures adopted to respond to them, should be guaranteed. And the Paris Agreement in this regard refers more generally to enhancing public participations under Article 12 and to participatory approaches in the context of adaptation measures under Article 7. Overall, on the basis of the four general principles of the CRC, it has become increasingly clear that as climate policies and programs are formulated, one of the main objectives should be to fulfill human rights by taking into account the specific risks faced by all children without discrimination, their unique developmental needs, the identification of their best interests, and the incorporation of their views in accordance with their evolving capacities.